Attorney General, he's been in office about 10 months, just under a year. What has surprised him and what about the job is different than you expected?
Before I answer that question, first of all, let me thank Common Cause for having me tonight, and congratulations to all the award winners. It's great to finally be here. This is not the first time I've been invited. In 2017, after I stepped down as U.S. Attorney, or more accurately, expired by the President. I got a call from John Henry. They said, look, our annual meeting's coming up, and I think a lot of them could ask me to speak to me. I was feeling a little lucky there. And I don't remember this, John, but John said, can you help me get Preet Bahara from New York? And I have to tell you, as U.S. Attorney to serve with Preet, that hurt a little bit, John, but it's good to be here. So what's been the biggest surprise? Louder?
And slow.
And slow. Yeah, when I was a trial lawyer, the only, Mr. Oxford's, would say the only person who spoke faster than me was Davis Cicilline. Yeah, so what surprised me the most? Two things. The breadth of the mission. On any given day, I could be discussing with the privileges of homicide and province. In the afternoon, I could be talking about hospital consolidation. Every day, we could be talking about environmental enforcement. So the mission is broad. The office is small for what we do. So I don't think we're staffed. I think we need to serve people well. The other thing that surprised me, or was reminded of more accurately, is how hard people work in the office. I'll just share one example with you. When I took office, there were 1,697 cases that needed to be moved through the charging pipeline. And I won't forget that number, I think, for as long as I live. Because I worried about it. And to really to solve that problem, we needed to change our intake unit, which screens are, those are felony charging. Put more resources down there. Reassign them. You don't give you resources in the middle of the year to get them at all. But it's a testament to those people that by mid-year, that backlog was gone. And the people in that unit came in, and I won't forget this either, 4 consecutive Saturdays in April to get that job done. And the people in my office don't get paid extra for coming in on a Saturday. They don't get paid overtime. They just did it because they knew they needed to do it. It was the right thing to do. And what they got from it was a pizza that some of us didn't want. So, I'm really amazed every day by the work of the people in the office. I'll stop here, but they carry huge caseloads. Our special victims unit that I would argue handles the most sensitive cases. The victims are children, women mostly, that were victims of sexual assault. Those prosecutors are carrying on average 135 cases each. And for those of you who practice law, you know that is an almost unmanageable number of cases for anyone to carry. So, surprised by the breadth of the mission, amazed by the work of people there.
So, how does what Jack's feel about 38 studios back in the news? The governor wants to make the records of the grand investigation in the case public. And I have a couple questions from those in the audience here. In the interest of transparency in government, will you release the grand jury testimony in the 38 students case? And if you are opposed to releasing the testimony, how is the Rhode Island taxpayers supposed to find out the truth of what happened?
Yeah, look, it's a question I thought a lot about. And the truth is, under the current state of the law, grand jury materials are not by law disposable. It's not a matter of discretion, it's a matter of law. And so I'm really confident that the Supreme Court's going to affirm Judge Gibney's decision, because I said his decision, not releasing those materials. It's unlawful for a prosecutor or a witness before the grand jury to talk about what occurred before the grand jury. There are lots of reasons why that's the case. So there are some exceptions. There are exceptions when There are exceptions when there's civil litigation. For example, we don't have that here. So, but you ask the question, how do we find out what's the solution to that issue? I think one thing we can do in Rhode Island that we don't do, with respect to my legislative colleagues, is we don't put an oversight of legislation. I think too many times the Attorney General is asked to exercise the oversight function. I think we see that almost every day today. That we're asked to step in when things are going on at the legislature that are not corruption, frankly, or are not criminal, but because someone thinks something is being done in a way that people will improve, but that our office is asked to come in and do oversight. And I don't think that's an appropriate role for our office. I do think, though, that there is a solution to the 38 studios conundrum. It's this. It's the legislation that we put in last year to allow the issuance of a grand jury report. A grand jury report would be something that the grand jury could issue with the approval of presiding justice, with due process protections built in for those affected, and it would be used, I think, once or twice in the course of a term, maybe. But in cases of real significant public interest, I think it would be useful. I'll give you one example of why I think that's the case. We hear a lot about the investigation by the Attorney General of Pennsylvania into clergy abuse. And the Attorney General of Pennsylvania did a report. And in that report, he identified 300 clergy members that had engaged in inappropriate conduct. The reality is that investigation yielded 3 indictments. What the Pennsylvania Attorney General had, however, was a grand jury report statute. And so he was able to, Josh Shapiro was able to issue a report. That case in Rhode Island today would be 3 indictments. And what we would know about the state of clergy abuse in this from Pennsylvania was that 3 priests were being accused of misconduct as opposed to 100. So I think there's value in that grand jury legislation that we put in last year. We did not get it through the House and the Senate. We'll be back with it again this year. So I understand the issue, but to reach the conclusion I think many Rhode Islanders want, whether it be 38 studios or any other businesses, you've got to change the law first.
Is that your top legislative priority for 2020, and what other legislative would you say that?
That's the one though. I think the other thing that we need to change for now is our consumer protection statute. We have, with Michigan, the worst consumer protection statute in the country. So, specifically, what do I mean? We have a really weak consumer protection statute in Rhode Island. What specifically do I mean? What I mean is that if it's a regulated industry, being regulated by any state or federal agency, the Attorney General cannot use our consumer protection statute to go after that conduct. So, banking, public utilities, credit card companies. If you're a regulated industry under our consumer protection statute, as interpreted by the Rhode Island Supreme Court, we cannot do an investigation. In the wake of the gas outage on Atlantic Island, the Senate passed a resolution asking us to investigate. We could not investigate. We have no ability to issue a civil investigative demand under the current state of the law in Rhode Island. But I issued a civil investigative demand to get the information to do that investigation. National Grid Fund Court and got that civil investigative demand quashed. I think that's a real problem for Rhode Islanders. I think Rhode Islanders expect their Attorney General to be their lawyer, to be the people's lawyer. And until we get that consumer protection statute fixed, until we get that fixed, we're not going to be able to do that. The Senate passed that last year. The House did not. So that and the grand jury bill are among my biggest priorities, along with our drug reclassification bill, which I think is a critical part of criminal justice reform.
Speaking of criminal justice reform, I have a couple of these questions here about marijuana and the legalization of marijuana. What are your concerns as the state's chief prosecutor? Because it is likely that recreational marijuana will become legal here, as it already is in Massachusetts, still federally illegal, and folks still have a lot of concerns about younger people. And the question here is, how do we ensure that it does not become a gateway for dangerous drugs that protect individual and public safety?
Yeah, the gateway drug issue is hotly debated. There's some people think that marijuana is a gateway drug, and others who think it's not. My personal view is that it isn't. I'm not concerned about people using marijuana as adults. I am concerned about child use. All the evidence that I've seen in my years before as U.S. attorney and now on the job is that until an individual reaches 25, marijuana use is a real problem. But my most basic concern is this, that ultimately the people of Rhode Island will decide that question directly or through their representatives. What concerns me the most right now is the inability to detect whether someone is operating a motor vehicle under the influence of marijuana. We have a case pending right now in Kent County Superior Court. I don't know where Judge Prosecuting is going to go on that case. He's a great judge. But if you have read the reporting about that case, you know, that's a really difficult case for us to prove liability. And that's a death case. Someone died as a result of that operation of that motor vehicle. So that's what worries me. Will we be able to protect public safety in the most serious cases involving operating under the influence of marijuana or other drugs? I mean, I remember sitting with Steve Dammer for a long time. We've been practicing law together as prosecutors since 1996. And talking about whether we've actually ever done a successful operating under the influence of drugs case. Neither one of us can remember one. It's a really difficult case to prove because drugs remain in the system for so long. So that's my biggest concern on marijuana.
So that was the case where someone was actually killed, and had it been alcohol in question, it could have been easier to bring the case, but because it's marijuana, what is not there? Is it the forensics that are not there? What is not there?
Typically, where there's an accident, you can get a search warrant and draw blood. You draw blood for alcohol, it's pretty easy to chart out, how strong the person was at the time of the accident. Much harder, if not impossible, to do when it comes to marijuana. Marijuana stays in the system for so long. So we don't know when the marijuana gets into the system. We don't know whether the marijuana can happen to drive it. And so, particularly in an accident case, it's one thing if an officer's coming behind a car and make observations about the nature of the driving. But when there's an accident, oftentimes you don't have that, and that makes it much more difficult.
Massachusetts is already legalized marijuana, and to me, what we're doing now, we saw this corruption case out of Fall River, where allegedly the mayor was shaking down all the dispensary owners. So how do you legalize marijuana without opening the door to corruption?
I'm really reluctant to go from legalizing marijuana to corruption as a matter of course. Anytime there is action by government, there's a potential for corruption, and I've seen that, frankly, more times than I wish I had over the course of my career, both on the line as a prosecutor and running an office. So I don't know that there's anything inherent about marijuana that could lead to corruption. I think wherever there is, where government action could benefit somebody, there's always the danger of a kickback. And we've seen that time after time, whether it be the North Province town councilors, case we did when I was U.S. attorney. I remember the Lincoln Town Administrator, which was the case I did when I was on the line. I've had to be a D's office. I remember the Lincoln Park corruption case we did, many years ago. So, wherever there's, and that was an issue of additional slot machines in exchange for a ride, potentially, conspiracy. So, wherever there's governmental action, there's always the potential for corruption. I have one quote about corruption is that it's really important that people, when they are being victimized by corruption, that they come to law enforcement quickly. It is the unusual case where waiting to report corruption makes the case better. If you wait 6 weeks or 8 weeks and then sort of announce the corruption in the press, that typically is not leading to an effective prosecution. And as I look back again over the cases that I've worked on over the years, the best cases that we built, whether it be again the North Providence case, Speaker Fox, House Financial Gallatin, those were cases that we knew about before the press, where someone came to us and we located something in the course of the work that we were doing. And I have to tell you, you didn't really ask the question, Dave, but I'm just trying to make a point. I really protect the independence of my office. I think the Office of Attorney General has to be independent in a way that other offices don't necessarily have to be. We have, I think, a unique role, and politics really has to stay at the door. We're tempered in a way that the other constitutional officers and frankly members of Congress are not. We're tethered to the law. We have a construct around which we have to make our decisions. And so I'm really careful not to let our office get used in a fight between other branches of the government where there's a war today and peace tomorrow. And guarding that independence and understanding when we need to act, and frankly understand when someone's trying to use us, and I don't mean that in an overly negative way, but use us as a chess piece in one of these ongoing disputes. I'm really trying to be careful about making a decision that will allow us to be used in that way.
Corruption was such a big priority for you as U.S. Attorney with the Speaker Fox case, the Ray Galveston case. I think maybe sometimes there's a feeling, well, this case has happened at the federal level, they have the tools to handle it. So how do you bring that same anti-corruption effort at a state level and
Yeah, look, I mean, I think you have to build in the office the ability and the willingness to do it. And the reality is that most people come to these offices, and I don't have to bring my fellow prosecutors out there. When I started, look, you want to get in there, you want to try your homicide cases. Many go on, because the pay isn't very good, into private practice, and you try 5 or 6 homicide cases. Now you can do any kind of criminal case, and you're on the races. But you've got to build in the office that expertise, and we're building. We have a terrific called integrity unit. And the truth is that Steve Neronha and I and Lee Goldstein, the Deputy Attorney General, I want to point out the second woman Attorney General in the history of the office. 74 Attorneys General, only 2 women as Deputy Attorney General. We need to change that. Frankly, someday we need more women as Attorney General. But we've got to build that capacity in the office, and so Steve and I are bringing our federal experience to kind of train some of our more talented lawyers to do that kind of work. So you can do it in the AG's office. We did it. You know, when I was an AG, we prosecuted the town administrator in Lincoln for shaking down people and taking bribes. So we can do those cases in the office. You've got to have the will to do it. You can't be afraid of doing it. You have to recognize that if you do it, you may go up to the hill with your legislation or your budget and get a cold shoulder or two, but you can't shy away from that fight, because if we don't do it, who else is going to do it? And so I'm committed to doing that work, and I expect, I hope we don't have to do it, but it needs to be done with us.
I have a couple questions here about the incident at the Wyatt Detention Center. First, what is your rationale for not filing charges in that protest situation? And this one says, we quote your public statement regarding the Wyatt grand jury, but we feel we hold a further explanation because we know prosecutors play a big role in shaping grand jury outcomes.
Yeah. So, you know, the Wyatt situation is one that I've given a lot of thought to. So there's lots of pieces of that conversation. So let's just sort of play out the most difficult ones. Why is the grand jury in the first place? Why is the grand jury? There are a number of reasons. Number one, certainly if you're going to charge a case where there's a lot of evidence, you want to make sure you have all the evidence before you charge it. So certainly you use the grand jury to obtain all of the evidence that you need. You never want to be in a situation where you're charging a case. So let's say I had taken sort of the video that Steve Alquist here shot that night and took a couple of police reports and signed in information and charged it. As part of my discovery obligations, which I think anybody in the room would agree is an important obligation of a prosecutor, we have a duty to turn over any relevant evidence, exculpatory and inculpatory. I would then have to go find all the video out there and turn it over. I have to take all the witness statements and turn them over. But I have to do that really fast, because every day that I delay in doing that, I'm behind the discovery curve. So why use the grand jury? To get all the information you need. Let's say there's someone who doesn't give you the information you want. Let's say, for example, that the Wyatt won't give you their videotapes. I can't get that without a grand jury subpoena. So there's lots of reasons to use the grand jury. You use the grand jury in lots of cases. We use them in public corruption cases all the time. Virtually every death case that involves driving don't have to use the grand jury, but we use it. Every single case that involves excessive use of force by police, we don't have to use it, but we do. Why? Because you want to make sure you get the evidence, and sometimes you want the grand jurors to take a look at the evidence and put it in context.
Would that incident at the Wyatt be an example where if we had an investigative grand jury, not two indictments, that would help clarify what happened for people?
Yeah, look, I think it might. You know, obviously I can't talk about this, as to why. Sort of how we presented the case to the grand jury, other than in generalities, and certainly the grand jurors. Just understand how our grand jury works too. Grand jurors, 23 people go on with the voting list. We don't pick the grand jurors, the court does. recite that, it's from the DMV list. So there are 23 Rhode Islanders, and they vote. There are 23, but 12 need to vote to return an indictment. 12, not 23, 12. It's not like a trial jury, not like a trial jury. So you only need 12 votes. And I met that grand jury because they reported that case out on the last day of their service. And I can tell you, it was a diverse jury. It had blue collar and white collar folks on it. It had people of color on it, and old, young. Frankly, a typical Providence County grand jury that works 6 weeks straight on that whole bunch of other cases. And I'll never criticize their work. You know, I'll say this, I've tried plenty of cases as a trial lawyer. I've run offices where lots of results have come back that I didn't expect sometimes. I'll give you one example. North Providence case, we forget this sometimes. North Providence case, 3 town councils were convicted. The person who delivered the bribe on behalf of the developer was convicted. The developer himself went to trial and was not convicted. Can I explain that result to you as I sit here? I can't explain that result. But the jury did what it thought it was right. It thought it was right in that case, and I respect it as I do here. I will say this, there's been a narrative that the prosecutors had an agenda in that grand jury. I can tell you that that is not the case. I put our best people on that case. I wrote the jury instruction on assault myself, but I wanted to make sure that we had the law right. You know, one of the questions that I received was that some of the protesters were concerned about the questions that they were being asked, questions about what they were doing when pepper spray was deployed. And, you know, I don't know what the grand jurors were thinking as those questions were asked, but I'm pretty sure I know why those questions were being asked. We asked jurors to evaluate 2 things. We asked them to consider the actions of the truck driver on the land question, and also whether or not the correctional officers had deployed pepper spray in an appropriate way. And so what drives that pepper spray determination is this. Was the conduct of deploying that pepper spray objectively reasonable given what was going on around? That's what the Supreme Court requires as a finding for the use of force to be excessive. And so to understand that, to understand whether or not deployment of pepper spray was appropriate or not, the prosecutors, in my judgment, had to ask the people who were there what was going on when the pepper spray was deployed. And so that means asking questions. Were forces being raised? Were people responding when correctional officers asked people to move away from the truck? And without getting into what the answers were, I can understand how, if you're a witness in that context, you might think that those questions are being asked because someone thinks that the protesters are doing something wrong. But what the prosecutors are trying to get at there, and what the issue there is what is going through the minds of those correctional officers at the time they deploy that pepper spray. It is one thing to deploy pepper spray when no one is making any noise at all and standing there doing nothing, and something else when it's a chaotic scene. And so there's a lot in what I just said. I hope that answers some of the questions. But I will tell you this, and I want to come back to it, that the 2 individuals who put that case in the grand jury, there are two individuals that I have more confidence in. I already mentioned one, Steve Gamble. Jim Baum was done. Steve Gamble has been a prosecutor since I think 1990 or so, maybe 1989. He has prosecuted some of the most difficult cases in the state. He prosecuted Jeremy Motika for murdering a woman in a bathtub and raping her in Little Compton back in the 1990s, among other serious cases. He's a terrific attorney. He gets it right. He stood up when the strike force under one of my predecessors was a real problem and protested because he thought it was wrong. My prosecutors did not go into that grand jury with an agenda. They went in trying to get it right. I understand that sometimes people will disagree with the result of a trial jury or a grand jury, but all we can do as prosecutors is present the evidence, give the grand jury the laws we understand it to be, and then we accept the result, because that's our democracy.
What role does social media play in that case or other cases, right? Because as soon as that incident happened, you see people tweeting it out. You see the video going out, the comments, and some of those people who disagree with the decision, right? They're going to speak out through that form. So how has that changed, what you have to do and what you have to consider?
Look, you have to, again, I mentioned earlier, we're tethered to the law. And so, look, I'm aware of what goes on around me. I I understood once the grand jury reached the decision that they did, that there would be some anger about that decision. It's why I met with the protesters before I spoke to the media. I felt like they deserved to hear it from me. Notwithstanding that I knew that was going to be a difficult situation, and I understand why it was difficult, I respect that. But we have a job to do, and it doesn't matter, what the case is, or what kind of case it is. We have a job to do. I like to think that the office is doing a good job in that space, and I'm really committed to trying to get it as right as I can.
Common Cause has staff just devoted to the 2020 census, and that's right around the corner. The results will determine redistricting all across the country, and in Rhode Island here, we could potentially lose a representative based on that. The Trump administration has moved to collect citizenship data from some of the states using DMV records. We haven't been asked yet, but if we are asked to provide that data for that purpose, should we cooperate? Why or why not?
Now look, I think the first question there is to understand what the data is being sought, what the rationale is. And frankly, that is the governor's bailiwick, to talk to her and talk to her or her team and figure out where they want to go. I will say this, that this administration's record on the census is not strong. Even in the case of New York, where technically, I joined with other AGs in that case before the Supreme Court, where the administration sort of won, to have a court question the administration's motives as to why they wanted the question. It's really an extraordinary thing when you think about it. It's extraordinary. Whether it be in the context of the census or a lot of other administration policies, I think in the past, I worked for Republican presidents and Democratic presidents. I worked for Republican AGs and Democratic AGs. This is different to me. This is different. This is we've reached a place in government, in the Justice Department, where the stated reason may not be the real reason. And it may seem naive to think that that's a new thing, but I really feel like it is. I was in the Justice Department for 15 years. And I felt like what we were getting out of the department, regardless of whether we agree with the policy or not, the stated reasoning was the real reason. I don't feel that way now, and that concerns me a great deal.
Do you feel like has the job of Attorney General or U.S. Attorney been politicized, and how do we come back from that, if so?
Yeah. It's hard to say on the U.S. Attorney side. I'm part of a committee that meets with the Justice Department now on a quarterly basis. I've only had one meeting since I've been Attorney General. I would say the department feels very different inside the building. Frankly, it's a much less diverse place than it was when I was there. Certainly the younger management. Attorney General Barr I've only met him once, been in a room with him once, for about an hour or so, and it's I'm still not sure what to make of him. I think as Attorney General, I alluded to this earlier, it's really important to separate the politics from what it is we're doing on a daily basis. We have a job to do, and that's a job that, as we talked about tonight, can put you in places where, people aren't real happy with what you're doing, and so you've got to be guided by whatever compass you have inside you. And that's what I try to do. I have a sense of what it is we need to be doing. And I have a sense, too, that as AG, you've got to push the office in certain ways. I felt this as U.S. Attorney, too, that there is certain work that's going to come to you, but if you want to make progress, then you as Attorney General or Attorney have to push the office in that direction. I'll give you a couple of examples. Wage theft. We really have not done much in the office around wage theft. So misclassification of workers, organized labor, unorganized labor, we're really making a big push there. And we've already had some results. I expect we'll have more. But that's something that, as Attorney General, you've got to drive, because that's not going to happen unless you do it. Environmental enforcement is another one. We haven't been doing a lot of environmental enforcement in the office. if you're the Attorney General, you've got to drive it to make sure that that is one of your priorities, because particularly in that civil division where a lot of that enforcement takes place, you've got to defend the state, and you can find yourself caught up in simply doing defensive work. You know, heaven forbid DOT should run somebody over, well, you've got to defend the state in that case. But if you want to go on offense, and I love being on offense, you've got to drive it, because if you don't, what you find is you're doing defensive work most of the time.
A question here from the audience that is very close to my own heart. Do you support a federal shield law that will provide a qualified privilege for reporters to protect their sources? And this is something that my colleague Jim Terracani, before he passed away, had pushed for, had gone to Washington for, and something we still don't have today.
Yeah, I do. I think I do support that. I think the only context in which that privilege ought to be breached is in the context of national security. I mean, real national security. National security is broad. You can paint with a really broad brush there. I'm talking about a real significant threat to safety. And I like to think that privilege probably would apply in that context anyway. Oh, look, I think the media has an important place in our democracy today more than ever. I've tried to be accessible to the media. One thing I don't know that I've ever, since I took office, turned down a request to speak to the media. A, because I think it's important that we be accessible, but also because I feel like I can best explain what I've done than anyone else. And so, if I'm given the opportunity to try to do that, I want to take advantage of it. So I think it's important that the media have a robust role today, and I think it's important that as public officials we be accessible. And the reality is we're always accessible. I mean, sometimes I wish it were otherwise. But our phones are always on and they're always with us, so there's very little reason for us not to be accessible to the press and to the public.
You talked a little bit about reclassifying drugs and changing the laws surrounding that. I have a question from the audience here. Are you willing to use prosecutorial discretion to redirect people through a restorative justice process instead of incarceration?
Yeah, sure. So we've done some good work there. So when I took over as Attorney General, we were running in the Office of Diversion Program. And what a diversion program is to divert it out of the criminal justice system. So our diversion program, which is run by the office without any court involvement, I would describe it as trying to get a camel through the eye of a needle. I mean, to get into that program was very, very difficult. If you were a URI student and you sold marijuana to another student, you were a drug dealer and you weren't getting into a diversion program. To me, that's exactly the kind of case that should be in our diversion program. And so what we've done is we have taken our diversion numbers and more than tripled them. So we have 3 or 4 times as many people in our diversion program today than when I took over. It used to be that if a judge wanted to put somebody on our diversion program or a prosecutor wanted to put someone in our diversion program, our caseworkers could say no. And to me, that was, we were inverted there. To me, if a prosecutor and a judge take a chance on a young person, and mostly young nonviolent offenders, not universally so, then we need to make that happen. Our diversion unit has to reflect the community that we're serving. And so, many of the people in our diversion program are Caucasian, many are not. Many are Latino, many are African American. So I hired an African American young man to work on our diversion program. We roll out young men that are in our diversion program. So that's gone well. And the legislature did a great thing this year, passed a diversion court. So I want to thank Representative Williams and Senator Sheehan and I see Representative Corbett out there as well, for getting that legislation passed. Because now we're going to be able to marry our diversion program with the court's diversion program and put more people through that process. Our prosecutorial resources should be on people who truly drive the most significant crime, violent crime against vulnerable victims, children, public corruption. And where we can get a lot of the criminal justice system, we need to do that. The way the diversion program works, just so you know, is you go into the program, you make it right, you do community service, you pay restitution, you need counseling, you get it. And then at the end of the day, 12 months, 18 months out, the case is dismissed, so you don't have that felony conviction. On the drug reclassification side, that's another bill that we brought in last year with a lot of help with the legislature. Passed by the Senate, I believe, but I'll make your moment about that. A lot of support among the rank and file for that bill. What that would do would change or reclassify simple possession of small amounts of any kind of drug, used as a misdemeanor rather than a felony. Here's why. Here's why that's important. No one goes to jail on those cases anyway. There was a lot of pushback from law enforcement to me for that bill. People I respect very much worked for a long time. So we ran every case involving fentanyl. Everyone would agree that fentanyl is the most dangerous drug out there. Of the 40 people who were charged with simple possession of fentanyl over the last several years, one person went to jail. That was as a probation violator for 30 days. Most of them went into drug court or were given a suspended sentence or probation counseling. So our argument is this. Why not sending these people to jail anyway? Why are we making it a felony? Let's make it a misdemeanor. Let's treat it as a public health crisis it is. When they're through addiction and into recovery, let's not hang that felony around their necks, which makes it so much harder to get a job, to get housing, to get financial aid. It's not a difficult lift, and it has bipartisan support elsewhere in the country. We should be able to get that done in Rhode Island. I'm hopeful for that this year.
When we talk about criminal justice reform, we have to think about the people, many people, thousands who are on parole or probation already, right? And many times they end up going back to the ACI at the state level for these lower level violations. And sometimes folks can get caught up in that system because they missed a court date, they didn't have transportation to get there. They haven't committed a new crime, it's a violation of the old parole or probation. So how do you keep people moving forward, making progress, while not sending them back to jail for these minor infractions?
Yeah, look, I mean, I don't think we shouldn't, and we can't send them back for minor infractions. It's a delicate balance. You just have to read about the case involving Joel Francisco to know what a delicate balance that is, right? He's a man who, after serving 25 years in the case prosecuting the attorney's office when I was there, is released from prison, has a few problems along the probation trail, murders somebody when he's out. That's always the risk when someone's on probation, right? That's always the risk. But you got to be willing to take that risk. And without talking about that case specifically, you can't be afraid to lean forward around some of these cases and just recognize that sometimes they're not going to work out. Obviously, Francisco's an extreme case. I'm not talking about that one. So what do? We have to understand which probation violations are significant and which are not. But there's a more fundamental issue here from where I said, something I thought about a lot when I was an attorney. We've got to make sure that when people get out of prison, they have somewhere to go. They have something to do, that they have employment. Because if they don't, the odds of them coming back are really, really high. And we can do this in Rhode Island if we commit ourselves to doing it. When I was U.S. attorney, people getting out of federal prison, if you were employable, meaning you did not have a physical or mental health issue that prevented you from being in the workforce, you were employed within a couple of weeks of release 83% of the time. 83% of the time, that's an incredible number. On the state side, the number was less than 50%. What's the difference? Well, it's not the kind of person getting out, because the person getting out of federal prison typically has been there a lot longer. Served more time on a more serious charge. What's the difference? The difference is the number of cases that are on each probation officer's caseload. Federal probation officers have 40 people on their caseload. So when I'm released from federal prison and I'm working a job and I'm going off the rails a little bit, I'm not showing up for work on time, I'm not showing up at all, that federal probation officer is on it. But if you're a state probation officer and you're carrying 250 or 300 or more cases on your caseload, how many times are you checking in on that person? How many times are you picking up the phone and making sure that your person has a job? And so if we want to invest in criminal justice reform, my view is that's what we need to invest. Right? We can talk about criminal justice reform, and the state has done some great work there. Again, the leadership that's in this room. But if we don't invest in corrections, and not in the prisons, but in probation and parole, to bring those case numbers down, I don't think our long-term chances of success are very good.
Given that reform, we also need to look at the court fees and fines, because, having gone to the court to set up for that and spend a day there and sat there, I just saw person after person who, they want to pay a building, they're paying $10, $20, whatever they want, they're in and out of work a also trapping people in the system who are not violent offenders, financially trapping.
Yeah, look, I think that's a concern. I think cash bail is a concern. I know there's some time on that in this next session, I expect. Again, I think there are things that we can do to make it easier. I remember when I was attorney, there was a company in Swanson that would hire people getting out of prison. It's an Irish company. They're not there anymore, but that's the point. They were making sandwiches. And they would hire people to get out of prison. They would. But Rick didn't go into the park. Right? Now, a lot of people getting out of prison, for the reasons you articulated, can't get their driver's license because they owe costs and fines. Right? So there's a job for them, but they can't get there. Right? And sending Rick another 2 miles down the road is the kind of thing we can do with this public health. I think the governor has done a great job of putting together this group to study some of these barriers to effective reentry, but these are not things that necessarily require 6 months of the legislative session. Some of these things are a stroke of a pen. There's a great company called Rhode Island Building Futures that is training people getting out of prison, as well as people who've never gone to prison at all, to build a skill, teach them to weld, teach them to be carpenters. There's a guy named Bill Scott. I don't know if any of you know Bill Scott, great man, minister, worked for Amy's house for years. Taught people, 7 people at a time getting out of prison, how to be plumbers or electricians. I said to him, Bill, we can replicate this 150 times over. We can solve this reentry problem, but we've got to invest in educating and delivering skills to people who get out of prison. Otherwise, this back to prison pipeline is not going to happen.
We need to take a further look at expungement also.
Yeah.
About people who had, for instance, marijuana crimes in their past before marijuana was decriminalized, and they're carrying them around even decades later.
Yeah, we do. And frankly, we've got to bring expungement to everybody. We opened a community office on Broad Street Province, and we did that because we wanted to bring the office to the people of the state who don't see their Attorney General very often. So what are we doing there? How do we serve people on Broad Street? We're not there as prosecutors, we're there as consumer advocates. You shouldn't get into your office as consumer health, which is tremendous, by the way. It's tremendous work that the office does in the consumer space. 700 calls a month, helping people every day. But you should have access to our consumer unit based on where you live. And the same is true of expungement. So before we add eligibility for expungement, let's make sure that the people who are already eligible can get their records expunged. And so we're going to have an expungement clinic, I believe, in early December on the Broad Street office, where we'll be able, people will come in, we'll be able to run their records, we'll be able to link into our BCI unit down in Cranston. We'll run their records, we'll let them know whether they're eligible, we'll show them what the paperwork looks like, we'll show them how to fill it out. When they go to court to get their record expunged, we're on the other side of that, so we'll know they're coming and we know not to object. Because you should. Whether or not you have a record expunged should depend on the zip code you live in. It should be something that all of us have access to. And I will tell you that there is a underserved community, and we all know there's an underserved community, but there's a community that's underserved by its Attorney General's office. And reaching that community is one of my largest goals. And I think it's hard. We don't have a muscle memory there. Getting people to trust us is an important first step. I think we're making progress. But I will tell you, it's been something of a lift.
So you're saying to those folks, we want to help you expunge your record, but you are also working with people who send them to jail. So you have to build that trust there.
Yeah, look, right. I think part of it is understanding that when someone has paid their debt to society, it's done. We did a reentry summit when I was youth attorney for employers to try and encourage them to hire people getting out of prison. I had someone saying from Johns Hopkins Hospital Network on Rhode Island. Johns Hopkins has over 1,500 prior felons on their payroll. And the reason for that is, number one, they're working hard. Number two, if you rule out everybody in Baltimore as a criminal record, they're not going to have much to work with. That's just the reality. You can't sideline your workforce. And so the reality is that if we don't make these opportunities available, people are not going to succeed. So what's my point? one of the people on the panel was a guy named Dwayne Gibson. Dwayne Gibson did 25 years on a federal drug trafficking charge. Dwayne Gibson was on the panel. Dwayne Gibson got out of federal prisons, had a great federal probation officer, got him a job as pet food expert, who want to hire him, put boxes together, and he learned to drive a forklift. Today he's a manager, right? So there's a path to success here. We just got to get people on the path. But look, my thing is this: when you have served your sentence, it's our job to embrace you the way the public needs to embrace you and get you back to where you need to be. That helps all of us. It's the right thing to do. It's a smart thing to do. Economically. I have one caveat. My caveat is this: that if you have committed a crime involving public corruption, I don't think you should be able to run for office again. I don't think you should have that privilege. But short of that, Godspeed to people once they're released.
We saw that Mayor Sansi, right before he passed away, ran for mayor. Really, there's nothing on the books stopping someone, Gordon Fox, for instance, from running for president, right?
No, there isn't. I remember, I can't remember exactly which case it was. It might have been Speaker Fox. I think it probably was. We were announcing that charge around the time of that election. I remember using the phrase political corruption amnesia. I think sometimes we do suffer from that here in Rhode Island, that there's this notion that a certain level of roguishness is acceptable. I just look, I've been very fortunate to be in public service. I left Goodland back in Boston back in 1996. My wife and I moved home. I've never had a private client here in the state of Rhode Island. I feel both incredibly proud of that and also incredibly privileged to have been able to do it. When you raise your right hand and take the oath, whether you're the U.S. Attorney or the AG or a special assistant AG or an assistant U.S. Attorney, that's an incredible privilege to represent the people of the state. To walk into a courtroom and stand up and say you represent the people of Rhode Island or the government or the United States, incredible privilege. And if you've broken that oath, I don't think you should be able to have that privilege.
You talked about a certain level of roguishness or corruption being acceptable. We have a question from the audience here. What are some of the issues and problems that you deal with that are unique to Rhode Island when you talk with your colleagues in other states?
I don't know that it is unique. I mean, one of my best friends is the former U.S. Attorney in New Jersey, Paul Fishman, and he obviously had plenty of corruption in New Jersey on his watch. And there are others, Chicago, and then there are sort of other places that don't seem to have much, the Dakotas. Water, I'm not sure, but I don't know that Rhode Island is special in this regard. I do think, though, and I said this earlier, I do think it's important that when someone is being victimized in this way, if you're a private citizen or a business person, you're being shaken down, then you need to come to law enforcement. We're not hard to find. Our track record is pretty good when we're brought in early. And I think if there's a message I want to get out there, it's that. It's look, if you think you've been threatened, if you think a bribe has been solicited, if you know somebody who has, reach out to the state police or the FBI or the AG or the I don't know that there's, beyond national security, I don't know that there's a bigger threat to the well-being and safety of our state. And look, the vast majority of public officials do it exactly the right way. That's the vast majority. But when there's a handful, and it is a handful, of course, my 20-some-odd-year career, in personal experience, 5, 6, 7, maybe 10. That's a small number, but it shakes confidence in what we do. We talk about 38 studios. Underlying the 38 studios thing is a specter of corruption. Let's face it. People are hoping, expecting, fearing that if those records get released, it'll expose corruption. I don't think it will. Based on my review, will expose probably just a lot of stupidity. But it's that specter of corruption that holds us back. I said this in the wake of the North Providence case, where there was acquittal of the developer. I said, look, if you're paying the bribe, you're as much of you're as big a part of the problem as you are to receive it, right? Both sides of the transaction are a problem, right? You don't have to pay the bribe, you can come to law enforcement. That's my red line corruption.
Speaking about increased consumer protections, you worked on a new student loan bill, right, with the Treasurer Magazine was here tonight. What was included in there, and do we need to go further when we're talking about so many young people who have overwhelming student loans?
Yeah, I'll give a shout out to the treasurer, who's a real leader on this, and has led it for a number of years, and we were grateful to be able to partner with him on that. You know, it's interesting, we talked earlier about our consumer protection statute. We had to put a fix in that student loan bill to be able to do it at all. So if we just passed the student loan bill and then linked it back to our general consumer protection bill, we wouldn't have been able to do anything, because guess what, loan services are a regulated industry. So we had to put the fix inside the bill. Put the fix inside the bill. Kind of snuck it through there, maybe, I don't know, but you know, we got that one through. You know, it remains to be seen how much activity we'll have in that space. I suspect there will be complaints coming in as people are familiar with the work that we're doing. I have no doubt that the law will be challenged and we'll need to defend it. I'm ready to do that when that happens. In the meantime, the staff has been trained to take those complaints, and we'll see where it takes us. But it is, look, it's heartbreaking to talk to your station, I think, at a student loan town hall recently that the treasurer and I were on, and it's heartbreaking to see these young people who are making choices, life choices, career choices based on student loan debt. And I think in many ways it's holding us back.
So a big part of my job involves requesting public records, and it could be something serious. It could be about criminal prosecutions, or it could be about, I had one recently that was all about trash cans in the city of Providence. So what we found recently is that the government agencies are following the letter of the law, which is that you have 10 business days to respond, and then a possible 20-day extension, but not the spirit of it. So every request basically is taking 30 plus business days. How do we better work together?
Yeah, you know, open government has been a priority of mine since taking office. There's no question that when I took office, there was an ongoing issue involving open government, the way we were, basically our approach. And look, my predecessor's approach was not one that's not grounded in law. It's how you look at this. And certainly the dispute between Representative Morgan and Attorney General Martin took about really fast, and we needed to get that fixed and frankly turned around. But underlying that was, you know, a change, I think, in approach, which was when in doubt, err on the side of disclosure. Whether we're talking about our own house, when we're doing open government issues after most of it comes to us, or when we're advising states and local agencies, or when we're weighing in on complaints that have been filed. I will tell you the number of complaints have skyrocketed. We have more complaints in the office to date than we've had in any year previous, over 150. That's a lot of open government complaints for our team to deal with, and they're time intensive. So, for example, take UHIP, for example. The UHIP journal, I believe, I was looking for UHIP records. We have to analyze every single document that the governor has that is responsive to determine whether or not she correctly held them or not. So think about that for a minute. We have to look at every single document ourselves, right? Every document that Representative Morgan wanted about our expenditures of Google money, over 30,000 documents, we can look at every single document ourselves. So when you think about what a resource drain that is on the office, it's really high. You have about 100 lawyers. That's not a lot of lawyers, about 30 in the civil division. And for every open government case that we're dealing with is a case where I can't be on offense. That's a defensive case, effectively. So I'm concerned about that. Look, it's an important mission. We want to do it the right way. We're committed to doing it the right way. But it is a resource drain. And to your question, Katie, I can't tell you what that resource drain is like inside, say, the clerk's office in Jamestown. I will tell you this, that we're making an effort to do a couple things. Number one, train really well. Train with a bent towards transparency. But at the same time, you know, if there's a city or town or public agency that isn't doing it the right way, you we're not afraid to bring legal action as we did against the town of West Warwick recently. What encourages me about that is this. At the time of West Warwick, after a number of issues around local government, reached out to us for training. I was really encouraged by that. To me, that ought to be the result, right? That we have to keep going back, finally strike hard a little bit. But the message is received, and I think they're trying to get it right. So we'll see what happens. But this is an area where I think everyone is spending more time these days than we were a decade ago.
One more question from the audience here. The legislation is amazing, but how do we better go about implementation? When we pass legislation, we have these big press conferences and events, and everyone cheers, and then there are examples where it falls to the wayside. Most recently, gun removal from domestic abusers. Now there is some data out showing that not all of the judges are asking those suspects whether or not they have guns and are making sure the guns are taken away. So how do we go beyond just passing the legislation?
Yeah, a lot of it depends on whoever's responsible for implementing the legislation. So, student loans, the proof will be in the pudding. We used to say in the Department of Justice, when the mothership asks you to do something, they're always coming back to measure it. A year from now, keep track of what you're doing, because the mothership's going to come and ask you whether you did it or not. And I think the public, the legislature, ought to come back and ask us, in a year, how did that student loan bill work out? How many complaints did you get? How much relief did you obtain? If you had trouble, what caused it? And I think some of that is on the media, some of it is on the public, some of it is on the lack of entities like Common Cause to hold us in government accountable. But we should expect that. I always expected it as U.S. attorney when President Obama asked us to shift from a charge everybody with the most readily provable, most serious offense to be more thoughtful about how you're charging. We knew that the Attorney General was going to come back in a year and ask us whether we did it. And so we ought to be thinking about that in government. When we're given that charge, we ought to be thinking about, you need to do it, are we doing it, are we keeping track of it? I think that's one thing I've noticed in state government, which I think is a real failing. We don't study ourselves, we don't keep good data. When I was U.S. attorney, if I wanted to see every kind of gun charge being charged, and there's lots of different kinds of gun charges, we could go into the system and they could run a report for me, and I know exactly who got charged with what the sentence was. It's so much harder to do that in the state system. It's probably a resource thing, but I think it really challenges us in a lot of ways.
All right, thank you so much.